Good morning. Welcome to the third meeting and the first public stakeholder engagement meeting of the Special Select Committee of the Senate on the Sexual Offences Amendment Number 3 Bill 2021. This hearing is broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I am Clarence Rambarat. I'm the chairman of this committee, and I now invite my colleagues, who are all senators, this is a Senate committee, to introduce themselves.
Good morning, committee. Senator Renuka Sagram Singh Suklal, committee member.
Good morning, Paul Richards, committee member.
Hi, good morning. I am Jayanti Lachmidial, committee member.
Okay, thank you very much.
Good morning, Mr. Chairman. I am Randall Mitchell, committee member.
Okay, thank you very much. The committee is supported by a secretariat comprising Mr. Johnson Greenwich and Mr. Brian Lucio. And we are also supported by the technocrats from the Office of the Attorney General and other agencies. I now invite the members who have accepted our invitation to be here. We have representatives from the Prison Service, the Trinidad and Tobago Prison Service, and the Trinidad and Tobago Police Service. So I now invite first the Prison Service, led by the Commissioner of Prisons, and then the Police Service, led by the Acting Commissioner of Police.
Hi, good morning, Mr. Chairman. My name is Dennis Pulchan, Commissioner of Prisons, and I have here my two officers comprised of my team.
Good day, Chair. Good day, members. My name is Mustaq Mohammed, the head of the Prisons Legal Office.
Good day, Chair. Good day to all. My name is H. Walcott, Chief Prison Welfare Officer.
Thank you very much. I would invite the Trinidad and Tobago Police Service now to introduce themselves.
Yes, good morning, please. My name is McDonald Jacob, Acting Commissioner of Police. And together with me here is a distinguished team. I'll let them introduce themselves. Miss.
Good morning, Superintendent Guy Allen, TTPS.
Good morning. I am Sharon Cooper, Assistant Commissioner of Police.
Yes, Mr. Ramawat, the chairman, and this is the team together with me here this morning who will be participating in this process.
Okay, thank you very much, Commissioner. So, Commissioner of Police, Acting Commissioner of Police, I would now invite you to make your opening remarks, to be followed by the Commissioner of Prisons.
Yeah. So again, good morning to all who are participating. Mr. Clarence Ramadat, Chairperson of this Joint Select Committee, Special Select Committee, and all other distinguished members. I want to give thanks to you for the Trinidad and Tobago Police Service, giving us this opportunity to participate in this process as it relates to this important piece of legislation that actually target towards the protection of the vulnerable men and women and children in our society. Looking at the stakeholders present today, it emphasizes the point that crime fighting is everybody's business. And if we see something, we should say something. It is my hope that our contribution here today facilitates the proclamation of this important piece of legislation and allow for the smooth transition into law enforcement in enforcing the law. That will not hinder law enforcement in its investigation. Instead, it will allow us to charge the perpetrators of these serious sexual offenses and protect our citizens. As we all know and anticipate, with this legislation becomes to be more enforceable, it will certainly be an essential tool in the fight against crime and to protect the communities. We also believe that it will add serious legitimacy to the police, because most of these reports, when made to the police, there's an expectation by the victims that the police respond in an effective manner. The legislation will put us in a position that we can provide that service that is required to our citizens, and that sort of confidence that is required in the police service will be enhanced. So again, on behalf of my team here, we are prepared to assist and contribute to this process this morning so that we can help to protect and serve the vulnerable, as was mentioned earlier. Thank you very much.
Thank you, Acting Commissioner of Police. I now welcome the Commissioner of Prisons to make your opening remarks.
Thank you, Mr. Chair. Members of the committee, all protocols observed. Pleasant morning to you all. I want to say that this is a wonderful piece of legislation introduced. It means it shows our country's maturity with respect to treating with offenses of a serious nature. It also deals with the protection of a child, which is particularly important to our country. I dare say that I'm a bit concerned, and as you know, we have the police doing detection, arrest, the courts will do sentencing, but there comes a very important part, which is rehabilitation, and that is where that falls in the jurisdiction of the prisons. What is unique at this point in time is that we need to beef up, or rather look for more robust retraining rehabilitation program at a professional level to deal with persons who would have been convicted of sexual offenses. The regular treatment, they will require unusual treatment or more professional treatment than what gives in the prison service today. I'm also concerned in the legislation, the list of persons and agencies that have been considered law enforcement officers. The prison service was not included in that list because of the fact that, I don't know, well, what I would like to see is prison officers included in that list because of the fact that we now have to do extensive DNA sampling of inmates. We have to do intrusive searches of inmates, and that may affect us in the performance of our duty. So it's something that I'm throwing out there for consideration. Other than that, you have the prison service full support. You have the prison service full support, and my officers stand by, and we are very happy to be here today to support in any way and contribute in any significant way for this meaningful legislation. Thank you.
Thank you very much, Commissioner Pulchan, and we appreciate what you've highlighted. Now, the purpose of this committee is the debate on this bill was completed in the Senate, and the committee was appointed to engage stakeholders, including the stakeholders who are before us today, and those who would be before us later on, and those who would make submissions in writing, and even members of the public who are following. We've not made a formal call for submissions from the public as yet, but members of the public who are listening or viewing can indicate or join, even if it means joining the chat on social media to indicate their thoughts, because a lot of important things in relation to the public interest would be discussed. Now, I want to open up now to the other members of our committee, and I want to say that in relation to two of my colleagues, Senator Richards from the independent bench, in his contribution in the debate, raised a number of issues, including The issue of private acts, for example, in a public place, the issue of rehabilitation, which Commissioner of Prisons you have raised, rehabilitation, and other matters relating to some of the detailed aspects of the bill. But one of the areas Senator Richards raised was the issue of rehabilitation. And then in connection to what both the police and the prison service are engaged in, Senator Lakshmi Dayal, in her contribution, raised a number of issues, including the issue of sentencing and the recommendation that at the point of sentencing, the consideration should be given to reference or referring the accused for psychological or other professional assessment. And Senator Varma Dayal Singh, the independent senator, on the issue of sentencing, also raised the possibility of, in addition to fines and compensation, the possibility of bonds, a person being put on a bond. And one interesting one was the person be prohibited from use of or access to the internet for a prescribed period. So I now invite first Senator Richards, to be followed by Senator Lakshmi Dayal.
Thank you, Chair. Good morning, everyone, and thank you to the stakeholders who are with us today. Start with the Trinidad Tobago Police Service and Acting Commissioner shake-up. Acting Commissioner, I'll use the word Commissioner. Do you have an issue with any of the definitions, or does your team have an issue with any of the definitions that are stated in the bill presently, including specifically private act, private part, and share or store in the context of the TTPS executing their duties in this intended law, which really deals with a very, very sensitive issue for the persons who would have been victims in the past, but certainly whom this legislation is intended to protect. And if you could disaggregate the children's aspect versus the adult aspects of this kind of legislation, please. That's the first question.
Yes. Well, as you're aware, this basically is an extension of our Sexual Offences Act that existed before, and some of the said terms and situations that exist here also exist in those acts. And in our normal enforcement over the years, we had no significant issues. So we don't expect it in these circumstances. So when it comes to the definitions and looking at it, we felt that it was clear. In some instances, there were some questions here and there, but when we go back to the notes at the beginning where it explained a lot, it cleared up a lot of issues that we had when we went through the legislation itself, the proposed legislation. So we don't have much issues in relation to the definitions that were used and the whole aspect of private and public.
No, what are your thoughts? And I know I think, is it Inspector Guy? Am I wrong? Or
Guy Allen. Yeah.
Guy Allen, sorry.
Yeah.
In terms of, if I'm not mistaken, she's with the Gender Affairs Unit of the TTPS.
Yeah, she's sitting here with me.
Yes, I know. I'm just trying to get her location in the service at the time. Given what you have been able to glean from the legislation, do you think that there will be challenges in the police executing this law effectively? Because while it is an amendment of the Sexual Offences Act, there are expectations for some levels of privacy with persons with regard taking of photographs and sharing of photographs and private parts, and I'm quoting from the bill here, in the definition means the genitals, the buttocks area, buttocks of a person, breasts of a female person, whether or not the breasts are sexually developed. In the context, and share means publish, distribute, transmit, stream, sell, make available, or advertise. Sharing online, including websites via email, live streaming, or through private messaging services. Sharing offline, including through posts or distribution. We have entered a realm in the world where the digital domain is extremely pervasive in everyone's lives. And if one takes the proposed definitions here to the natural conclusion in the context of Trinidad and Tobago, there are persons who may not have a sexual gratification intention, but may be caught up by the law in some of our cultural practices in the country. And if you have given thought to that in terms of how you think the legislation can be adjusted to ensure that persons who do not intend to, or who don't have a sexual gratification component as is intended by the law, are not caught unwittingly. For example, carnival photographs, carnival streaming, people who are scantily clad and their breasts, buttocks, etc., may be exposed to one degree or another, and persons who are taking pictures and sharing or streaming may fall within the ambits of the law.
Good morning again, Superintendent Guy Allen here. Mr. Richards, you raised you have my mind bubbling at the moment. Because when we look at the legislation, it looks simple. And I'm seeing where police officers, during an investigation, we can follow the law because it's an extension of what we have before in the Children Act as well as the Sexual Offences Act. But you have brought some issues to the floor which can be entangled in this entire new law. It means that as a society, the police, we would have to do a lot of, if the law is go forward in its current stage, it means that as law enforcement, we would have to do a lot of sensitization to make our society understand the new law and understand new behavior within our society. So it appears as though the narrative within our society would have to be changed, and we have to be very cautious about our acts. I see no problem with law enforcement conducting investigations relative to reports made and, pursuing and following the law at this time.
There are parts of the law that also deal with police officers and their exemption from prosecution and the execution of their duties. Do you think, and this is for Acting Commissioner Jacob, do you think that these officers should be of a particular rank when being enabled with the powers to search particular suspects in terms of the digital storage of these devices, the apprehension of suspects who may be suspected of being guilty of contravening the law, and the storage and management of that sort of evidence because of the possible sensitive nature of some of this this content?
Yeah.
Or should it be any rank, or do you think there should be a particular rank level that is applied to this?
Yeah. It can be and should be any rank, but what is happening within the police service, we'll have persons who are specialized for the purpose of carrying out that exercise. In the police service, we have our check and balances. And within the operations, we in fact establish standard operational procedures, which we place in our departmental orders. And if that is violated, we can in fact take action departmentally to deal with the particular individuals. At all levels, we have a level of supervision. And because we are dealing with the whole aspect of digital issues, we'll have our cybercrime unit playing a very, very important role in relation to this aspect. So when we have these situations, you will find that our cybercrime unit will be the persons responsible, and they are the experts in the area. If we go to limit it to some rank, it will create numerous problems for us because the way the unit also is structured. You may have one inspector, you may have one first division officers, and you have a series of second division officers. But we are not dealing with rank in this instance, we're dealing with the persons with the relevant expertise, right? And I just want to impinge on the question that was asked to Ms. Guy Allen. And one of the key that we need to look at is the word consent. that was highlighted in the Act. So when we talk about persons in relation to the whole aspect of having the whole carnival events and things like that, the question, the word consent come up there in inverted commas and whether or not, and there's expectations that during the course of things, persons will in fact record persons. However, you'll have instances where things will happen that the person may not have planned that their, as they use the word, breasts maybe and the exposed. That may not be the plan, and someone did something unbecoming. Yes, we will have challenges there, but we know that our legal persons will guide us accordingly because everything is based on the circumstances and the situation. It is not just clear-cut. And as I said, we are accustomed dealing with situations like that. And when we sit down and we look at it, we are not even just guided by the statutory law before us, but also case law will assist us in making decisions. So don't matter how we try to couch the legislation, it is just the foundation. And this is where the case law and other authorities will assist us in making decisions whether or not to charge in different circumstances.
Before to my colleague, Senator Lashmadial, but going back to the issue of the rank of the police officer, do you think a police officer who's just out of the barracks, just graduated from the police training academy should be included in this sort of exercise, given their possible inexperience and the sensitivity of the content and the information and the types of situations that may be involved here?
Well, in the first instance, according to our standing orders, that no police officer with more than 3 years service cannot be really in a specialized section within, like to be in the cybercrime unit, which might be the specialized unit to conduct such activities. So the question of someone just coming out of the training college, having access to that, it will be virtually impossible because we try not to put persons in specialized sections until after they have a certain amount of experience in the job.
Thank you. I defer to Senator Lashmadial at this time.
Thank you, and good morning, everyone. Let me start off, let me get right down to the concern that I think would greatly affect law enforcement. I'll start with TTPS. Commissioner, do you have any challenge with the exceptions and how they are worded? So if you have the bill in front of you, I'll point you specifically to Clause 5. And we're dealing with the new 22A subsection 3. Now, this deals with what we call the innocent infringers. And of course, there's the exception created for law enforcement officers. Do you think that the way it is worded is sufficient to protect your officers from being accused of committing acts such as voyeurism and so on when they are performing their duties? So do you see any challenge arising for our law enforcement officers? Let me, it basically just says that where a person does not commit an offense under this section, if the acts that are alleged constitute the offense are performed by law enforcement officer in the lawful execution of his duty. Can you, and then it goes on to say that's carried out by authorized person for medical, forensic, scientific, or educational purposes. Now, I'm thinking about undercover operations, monitoring whether or not sometimes the police may be conducting surveillance and may engage in, viewing someone without their knowledge for the purpose of, and it may involve viewing them in situations that are, they have an expectation of privacy. How Do you think that this section is crafted in a way that would protect the officers from being accused of acts of voyeurism?
Yeah, but not just the section in itself, is the procedural aspect that exists within the police service.
Right.
And that is the reason why we have things organized in a particular way, and persons need to be supervised and things are documented. So if you're having an official exercise and it is organized and that they will in fact be protected, Right. And we were looking at, we had some concern in relation to D, because D talk about the acts that the person reasonably believe, and we were dealing with the whole aspect of the reasonableness, and we were considering it, when necessary for the purpose of preventing and detecting the investigation of crime, legal proceeding, and the administration of justice, or in the public interest.
Yeah. So, for example, as you mentioned, are the reasonable, because that's such a broad, subjective and results really in a court making that determination. Acts that the person reasonably be believed. If, for example, an officer is accused of, let's say, committing an act of voyeurism, that reasonable belief you're saying would be substantiated based on instructions coming from seniors and so on, and it's an official operation and all of that, right? In the absence of that type of formal instruction and, a clear plan, do you think that officers who may be conducting surveillance or any type of monitoring on their own, let's be in practical policing I'm talking about, do you think that they may run into a problem if, for example, they might be following someone or following up a lead and commit an act of voyeurism, or accused of committing an act of voyeurism?
Initially, they may be in some question will be raised, but all persons involved with that have persons who we call handlers. Handlers are basically, whether it is your corporal, your sergeant, who must have knowledge of what is happening. Then your handler, how to put it like in our terms, will be exposed, meaning to say a handler now will come forward and say, yes, I have permitted X, Y, and Z. So initially there could be a query, but it will be handled in how we have things organized within our operations concerning surveillance and otherwise.
Okay. With respect to, well, this is not really and this is something I guess I'll throw out to both yourself and the Commissioner of Prisons. If, for example, someone with a predisposition for voyeurism or one of those types of a penchant for taking photographs and sharing and so on, let's just say someone like that exists, so we find them and we don't detect them right away within the prison or police service, and they end up abusing that power and authority that they have by sharing these images, or abusing the power to engage in this type of activity. Would you support a higher penalty for persons who are law enforcement officers who commit these acts not in the legitimate performance of their duties?
The penalties stipulated in the proposed legislation is quite stiff in relation. But remember, this is a double situation for an officer. An officer, if found guilty, will definitely be out of the job.
Sure. Mm-hmm.
Right? So other than the stiff penalties that I'm seeing here, there are other consequences. So in that regard, I will feel that is in fact sufficient. And I don't believe that there is need to really increase the penalties per se. And also we had situations already where officers used their cell phones and actually made photographs of things we had an example in Tobago, and he photographed in fact, an accused person was hospitalized and sent it out, and that person was charged and was in fact convicted, right? Even without this legislation. Mm-hmm. Okay? So I'm saying that we we will in fact deal with things in a particular way, and I don't see the necessary need to increase the penalties.
Just out of curiosity, could you just tell me that in that scenario you described, what was the offense that the officer was charged with for taking and distributing the photograph?
I'll just ask my team around to help me because I cannot remember offhand. Yeah.
I just wanted to know that, what else exists in the law that could, assist with these things in the event that it doesn't fall within here. Sorry?
Mr. Chair, Janti, could I just piggyback on one of your questions, please?
Sure.
Just to ask, in your experience, and perhaps somebody else could answer, where an officer commits such a crime, would it be seen at sentencing, if he's found guilty, as an aggravating circumstance so that he goes to the higher threshold in terms of penalty?
Yes, definitely. That is where the person who is dispensing justice will take in consideration. Because when you look at the position that the officers hold and their responsibility, right, the magistrate or judge who making the decision will take that in consideration in deciding what sanction to be placed against the particular officer.
Okay. Thank you very much, Acting Commissioner of Police and Commissioner of Prisons. I think my colleagues have brought the discussion to a very important area. I myself made a note to engage both of you on this issue because law enforcement officers, particularly the ones that you are responsible for, can both be involved in the enforcement of the law, and essentially that is how you see yourself, but can also be perpetrators. And the jobs, in maybe particularly police officers, put themselves in a unique position to be both an enforcer and a perpetrator. As somebody following the media and social media, I have observed where images are available on social media of crime scene, of things that ordinarily should form part of the gathering of evidence, but they're part of what we see on social media. So I think my colleagues, both Senator Lachmidial and Senator Mitchell, are really getting to that point, one, of whether you see the need to have a higher penalty or more serious sanction for persons whose job it is to protect and serve and to enforce, actually becoming perpetrators. That's the main question. But I want to ask both of you, Acting Commissioner of Police and Commissioner of Prison, whether you have seen or have had to deal with an increase in the use of the technology, particularly cameras, cell phones with cameras, by law enforcement, which are likely to constitute breaches of the expectation of privacy by citizens, including those who are incarcerated.
If I may, Mr. Chair.
Yes, Commissioner Pulchan.
Yes, sir. From the prison's perspective, I think we have had no cases where an officer would have used his cell phone to send images of any inmates on the outside. We, however, have a unique situation where inmates are actually sending images of themselves in various states on the outside. A glance at social network will can reveal this. So while it's an offense, some people are actually committing offense by sending images of themselves outside, and that is governed under the Interception of Communication and under Prison Act number 1303. So we have our challenges with that in that regard. But very rare we have any situation where an officer uses his cell phone to photograph an image of an inmate. there are strict laws governing officers and their cell phone in the prison, and it's tightly enforced. So that's our position on this matter, sir.
But if I could just add one to your question, because something occurred to me when you were delivering a question. Can I go ahead?
Yes, Senator Richards,
Yes.
go ahead.
Following your question, and this is to both Acting Commissioner Jacob and Commissioner Pulchan, we have seen situations in the past where access to crime scenes, as you indicated, have resulted in live broadcasts of persons who are not part of the TTPS, broadcasting information and interfacing with evidence on crime scenes. And the question is, do the commissioner, acting commissioner, and Commissioner Pulchan think there should be included some clause, although it would maybe a breach of the police operating manual or the prison operating manual, and a breach of their standard operating procedure, to allow external persons some sort of access to these sort of scenarios, and thereby facilitate some sort of breach of the law, but themselves not using their devices or doing it themselves. Do you think that should be included here to capture those sorts of situations? So while they may run afoul of the police operating procedure and disciplinary issues within the police service, they may not be criminalized acts, allowing that kind of unauthorized access.
Wow.
I've already trafficked.
Well, basically, the way when you read the act and how it is couched, once the police officer fall outside of, remember, we have our professional standards bureau, and we also have our complaints division. And if an incident occurs, the professional standards will first conduct the investigation. And once it reaches the threshold for the criminal in violation of this proposed legislation, when it becomes law, the persons will be charged and placed before the court. Because when you read it, you will see that it caters for those situations, in the sense that if a police officer went about and went outside of his normal duties and publish or send this by viral in any way, and we have that evidence, he can be charged criminally. The only time it reached and go down to the threshold of the police complaints to deal with our police service regulations, where there are about 3 different areas within that regulations that cater for persons who publish items in that way, they will be charged departmentally. So I strongly believe that the way how things are couched, we will be able to capture police officers who choose to cross the line in this circumstance. Right? I look at the proposed legislation, and as far as I am concerned, right? The persons next to me may advise me otherwise, but as far as I am concerned at this time, I'm seeing where we will be able to capture situations like that if police officers choose to cross the line. Once they cross the line and they go into the criminal arena, they will be dealt with accordingly.
Commissioner, sorry, if I could just interject. I think what Senator Richards is asking, let me break it down in the simplest possible terms. There's an exculpatory section here for law enforcement officers who are performing their legitimate duty, and they are allowed to do certain things. But what if they themselves are not doing it, but they are permitting somebody else to do it? This is a country where you have people, police officers and wannabe police officers, who have live shows and they record things to go on their programs. We have a evening show hosted by a police officer who uses unofficial camera footage to give his views and opinions on crime scenes, and others who are civilians who do so. And this is a situation now where we don't want all of these people for their personal gain, because that's what I believe it is, and financial gain, to be falling under this exemption. what will the police service have a challenge in terms of all of these persons and drawing the line? Where is the line going to be drawn in terms of performing your duties, the execution duties, allowing someone else onto a crime scene to participate in recording or to do whatever it is, and with the, let's say, the acquiescence of the police officer?
And Senator, and also partaking in the surveillance of what should be private acts, exculpated for the police officers in the execution of their duty.
Mm-hmm. When what they are really pursuing might be a private aim for popularity.
And a personal gratification.
Okay, thank you, members. And Acting Commissioner of Police, before you respond, I just want you to answer whether you have seen an increase in complaints by the public or in complaints generally in respect of the issue of police officers in their conducting their duties, taking and sharing images which may constitute an interference with the privacy expectation of citizens.
We have not necessarily seen an increase in relation to that aspect with law enforcement officers. We have one or two instances that were dealt with, but what we are seeing in why this legislation is necessary, we are seeing that generally within the communities, we are seeing that is happening among our citizens other than police officers. So we have isolated situations in relation to police officers and law enforcement officers, but we have a significant increase in that situation with persons coming to make reports to the police in relation to exactly what we are dealing with here. But we have not seen that significant increase as the police officers are doing it on a regular basis.
Right, and the other point raised by my two colleagues, it is not directly related to the subject matter of this bill, except insofar as it relates to taking and sharing, and it's an overall concern. So the question they've asked is this practice of having access to information, having access to material, using your position to access the material, to do recordings, to take images, and among the many uses of it, use it in broadcasts. Is it something that has been raised before in the Trinidad and Tobago Police Service, and is it something that is likely to engage your attention?
It has been raised, and we, in fact, we're looking at it carefully and getting advice from the DPP in some instances to guide us in relation to those sort of releases that may be even on that program that they referred to. We had situations that we had to call in the host and speak with him because some of the items may be evidential and may interfere with our investigations when it is released and placed out there and might affect the case later down the road. So we have, in fact, run an educational program within the police service for police officers as it relates to that aspect, right? And as I said, when they cross it and the regulations of our police service regulations, in spite of persons believe that the penalties are not strong enough, but depending on the situation, if it amounts to discreditable conduct, the Commissioner of Police can dismiss someone from the police service as a result of some of those actions that when they actually cross the line. But again, as I said, there are instances where persons cross the line and they were charged criminally for those situations when they use the images in such a way as stipulated in this legislation here, and police officers were charged and taken before the court. I asked my colleagues here to try to research so that I can actually refer to the cases, and I will get it very soon that I can refer to it. So I want them to assure them that if there is something else they believe that can be included in the legislation that can add force to the situation in case law enforcement cross the line, we will not at all do anything to prevent it. But from this, on the surface of looking at it, we believe that it may be adequate to deal with those situations.
Okay, before I invite my two colleagues who have signaled, Senator Mitchell and Senator Richards, your references to training and education in the police service, and I'm sure it applies in the same way to the Trinidad and Tobago prison service. I just want to refer very quickly to three areas raised by our colleagues, senators who are not on this committee, and invite your comment on it. The first is in relation to matters raised by temporary Senator Walker, Senator Dial Singh, and Senator Sobers, the issue of sentencing, and this may be of interest to the Commissioner of Prisons, in particular, the issue of sentencing and whether the bill should really treat with offences relating to children by having more significant penalties than those relating to adults, as on the matter of sentencing. The second was raised by Senator Sobers and other senators on the issue of the cybercrime unit, and something that always arises, whether the cybercrime unit is equipped to deal with the offences set out in this bill. And the Senator Richards has also raised that issue, and Senator Sobers raised the issue of training, because we hear references to the training and the need for training and education. And the third area was raised by Senators Walker, temporary Senator Walker, and Senator Sobers, and this had to do with putting in this bill a provision relating to, sometimes you see in certain public spaces, a sign or signage that says that these premises are under surveillance. And I wanted to know if you have an opinion on that, putting it into the bill, that these premises are under surveillance and the legal consequences which flow from that. So I'll just invite both of you, Commissioner of Prisons and Acting Commissioner of Police, to comment on those three areas: sentencing, to the ability of the preparedness of the cybercrime unit to deal with the offences created in this bill, and the issue of making provision for having signage addressing the issue of a premises, public space being under surveillance. Thank you.
Commissioner of Police, if I may, Chair, before I attempt to contribute in this last regard, there was something I had raised my hand previously that I need to comment on, if you don't mind. With your permission, Chair?
Yes, please go ahead. Please go ahead.
Right. I want to support the Commissioner of Police in the fact that more rigid legislation, two, training and development of police officers. But I do share a concern. One of my concerns is, and I'll bring it in an example. Recently, last year, one of my officers was shot in Siparia, and footage of a 3-year-old child was seen running hysterically. Before I was able to contact the family to explain to them that their loved one has passed, the images all over social media. And I am of the strong view that instances of these should face a very stiff penalty, because it adds trauma to the lives of victims and families out there. My second point, there are times when police officers seem to be doing their job in the execution of their duties. The civilian population seems to feel it is okay to put a cell phone on the face of the police officer without permission. And I think that should be an arrestable offense. And some consideration should be given to a stiffer penalty on that, because it makes the police officer's job much more difficult. So those are my two contributions to the previous discussion. With respect to sentencing, I believe that consideration should be given to sentencing with respect to a proper rehab program, a mandatory rehab program, one that the prison service is in dire need of. I think that people who would have committed sexual offenses would require professional counseling. This is one of the things we do not have in the prison service, and it's sorely lacking. So it is an area of concern for me that we should have adequate counselors and adequate psychologists to deal with rehabilitation program, that when a person commits an offense and come to the prison, we must send them out a better human being when they come in there, or give them the opportunity for behavioral change. So that is my contribution at this point in time. So.
Okay, thank you very much. And Commissioner of Police, Acting Commissioner of Police.
Yes, yes, thanks very much, Chair. In the first instance, I want to deal with the last issue first in relation to the aspect of signs concerning surveillance. Now, when you go abroad, you'll see in a lot of instances that persons have, in the United States and other places, have the signs, but it is used in the context of providing a situational crime prevention measure, in the sense that when persons are aware that these signs exist, it will or should act as a deterrent. In some instances, some people use it and they may not even have, in fact, proper working cameras at all, but it just act as a deterrent. And I believe that when you look at the law, I don't believe it will be causing any sort of distress or interference with the law if these signs are existing. It is something that we can in fact practice in Trinidad and Tobago, because, as I said, it acts as a significant deterrent, and under the whole aspect under criminology, they actually promote that, as a significant deterrent for persons who may look to embark on dealing with in any kind of deviant or criminal act. The aspect of our cybercrime unit, yet they may be short of a bit of manpower, but they in fact have the necessary expertise and technological support to deal with the situation. And they are also enhanced but by our RAU. We have a research and analytical unit within the Trinidad and Tobago Police Service, which basically is an upgrade of the cybercrime unit and go a little deeper in dealing with all aspects of issues with cybercrime. I know a lot of persons may not be aware of that research and analytical unit, but it's a unit that was formed about 2 years ago, and it works hand in hand with the cybercrime unit. Also, the Trinidad and Tobago Police Service have support from other agencies within the law enforcement, where there is, in fact, other technological support. The software that we use and some of the very expensive license, I have to say, that is maintained is even given support from through the Ministry of National Security, in order that, and some of our international partners, to ensure that we are able to deal with the issue of cybercrime in Trinidad and Tobago. So I believe that we are there. As I said, they may need some additional manpower, but we are up to our game when it comes to the technology. As it relates to the sentencing, I will pass it on to Ms. Superintendent Guy Allen, who will deal with the aspect of sentencing concerning young persons. Ms. Guy Allen.
Okay, thank you very much, Commissioner of Police, Superintendent Guy Allen.
Thank you very much, sir. When it comes to the sentencing for perpetrators that are adults and the victims are children, we would really like to see an increase in the penalty. Children are one of the most vulnerable in our society, and we have a responsibility to protect them. So with the hefty fines, it will act as a deterrent to would-be perpetrators in Trinidad and Tobago. Another consideration, if the perpetrator is a child, a different penalty and different circumstances should be laid down by the courts when it comes to a child as a perpetrator. So in a child perpetrating, we would like to see where the fines are not so hefty and there's a sort of rehabilitation and, a process to bring that child back into society where that child will not be recommitting these acts.
Okay, thank you very much. What I want to do now is we have 3 of the committee members. I would ask each of them to ask their closing questions or have their closing reflections. And then I would ask the Commissioner of Prisons and the Acting Commissioner of Police to make the closing remarks. So after each member makes their intervention, you'll have the opportunity to respond. We'll start with Member Mitchell, followed by Member Richards, and then Member Lakshmi Diyal. Thank you.
Chairman.
Thank you very much.
Respectfully, Chairman, if I may also be given an opportunity, Member Sagram Singh Suklal.
Yes, sure.
Thank you.
Started Member Mitchell.
Yeah, thank you very much, Chairman. Chairman, please permit me to go back to the issue of the sharing of crime scenes. In my understanding, unless clarified, there is a bit of a lacuna. Now, with respect to the sharing of these crime scenes that could be very macabre and that also share the private parts of the victims, many of these victims, these persons are deceased, and therefore they may not fall within the confines of the law. So to the Commissioner of Police acting, would the Commissioner of Police, because I'm hearing him talk about discreditable conduct without really specifying an offense, would the Commissioner of Police agree to an amendment of the law where the sharing of the intimate image, that is the private parts of this victim, deceased, fall for consideration within this law?
Well, in responding, in the first instance, when we had a situation where the person was in fact alive, we are charged for malicious publishing under the libel Act, Section 8, right? 16, we are charged the person when I refer to the incident that is in relation in Tobago. And that person was also subjected to our police service regulations, as I mentioned, for publishing and releasing such information. The question of dealing with the deceased persons, that is a possibility that we can in fact look at. But even so, if it is done on this occasion, they will in fact be charged departmentally, and depending on the circumstances, it can run from the basic charge of publishing to the other aspect of amounting to discreditable conduct, depending on the circumstances and the investigation that is done.
Okay, thank
Thank
you.
you. Thank you, Chair.
Thank you very much. A very important point raised by Member Mitchell. Member Richards.
Thank you, Chair. Just a couple of comments before I pose my final question. I just want to put on the record that I disagree vehemently respectfully with Commissioner Pulchan that the public recording situations in the public space should be an arrestable offense. Very often, those recordings have been able to provide clarity when there were alleged police abuses perpetrated. So I disagree with that vehemently. And under some circumstances, it may be warranted, but certainly not in all circumstances. Public space is public space. Two, I'm surprised to hear that the acting commissioner said that there were situations where the broadcast of a content that may be evidentiary had to be dealt with behind the scene in terms of the content being broadcast and then guidance given about the issue of it being possible evidence and that not being a process that's legally vetted before it's taken and broadcast internationally. So that's surprising to me. And three, the question now is, and also I want to put in the record that children should be a totally different regime. And I think the Honorable Attorney General spoke to this at some length in his presentation, where these laws are concerned, where adults are concerned. And I agree with the rehabilitation that Commissioner Pulchan spoke about, because voyeurism is a disorder in the DSM, the Diagnostic Statistical Manual, and is subject to rehabilitative processes. So, and in many cases, these people will come back out into society, and if they're not rehabilitated, the likelihood of the offense reoccurring is very high, because voyeurism is stated in the DSM as one of the most increasingly pervasive offenses globally. The question I have in closing is that, so rehabilitation to me is critical. It should be mandatory. And the question I have in closing is, it was a suggestion from, I think, Dr. Dylan Remy, and I think temporary Senator Walker, and someone else who escapes me now, that the legislation as projected does not have consideration for audio recordings. And it's Senator Lakshmi Dayal, it now comes back to me, that suggested that people may have distinctive voices and interactions that may be private and quite intimately intense, may be the subject of recording and sharing, and have the same effect as a video recording being published, stored, or shared. And if the Commissioner of Police thinks that acting Commissioner of Police thinks it should be included in this legislation, because it can do the same damage as a video recording if released, shared, or published. Thank you, Chairman.
Thank you. Commissioner, go ahead.
Yes, again, Chair, thanks. Yes, we believe that it can be included. It will be significantly helpful, because we even go along to do sometimes in some instances with identifying persons by the voice, by voice recordings. And we believe it can assist tremendously, because sometimes it may not be just the voice alone, it may be a combination, maybe the voice together with other aspects, put together the evidence in order to charge the persons. Right? I just need to indicate that in some of these instances, in gathering the evidence tend to be challenging, and it really takes persons with the relevant expertise, even with the basic aspects of what we are talking about digitally, because sometimes we will see footage, right, by WhatsApp or other things, and it's being forwarded. And then sometimes to find who is the original person, it tends to be challenging for the cybercrime unit with the work that they are doing. And someone will want to indicate, well, look, how the police and everybody is seeing this and the police is not doing anything. And the experts in the cybercrime, whether it's in Trinidad or internationally, will tell you of some of the challenges. And that is the reason why whatsoever evidence that we can get to put together to assist, whether it's voice or otherwise, we will advise that yes, it should be included, although it will be a challenge because we will have to get that person with recording previously and thing to do the comparison, and we'll have to take it by an expert to say, yes, this is the voice of the person. We have to use other persons who have been interacting with this person for a period of time, and they have to be willing to come forward in order to identify the person's voice. So I'm just indicating, putting it in and having it there, it is not so simplistic to say we have it and it will take a certain amount of effort, but we are prepared in that way in order to bring law and order in Trinidad and Tobago. We are prepared to go the extra mile to deal with it. And our cybercrime persons are in fact prepared to go that extra mile.
Thank you very much. Commissioner of Prisons, do you have any views on this?
Yes, I want to say thank you to the members and you, Chairman, for allowing us to participate in this important discussion. I also want to say that one of the things we are looking at is in sentencing, and Senator Richards hit it on the nail head, is rehabilitation. And, voyeurism is a disorder indeed. And a person might receive probably a 6-month sentencing. But if we were to acquire a counseling period, it may not be sufficient time to have that person properly counseled. So what I would like to see is that in the sentencing, we would like to see that the training or the counseling continues for that person on the outside, so he completes the training necessary for his rehabilitation. That's one area. A second area I'm looking at, sir, is the issue of prison officers' protection under this new bill. Law enforcement officers. And while protections are afforded for law enforcement officers, it does not include prisons officers. And what I want to say is prison officers do intrusive searches with inmates. It's involved doing DNA tests on inmates. So it could work against them, and it could work against the prison officers. So they need some level of protection, and I would really love to see this included in this new clause. Thank you, sir.
Are prison officers required to take images and or video of inmates in these searches or these interrogations?
Mm-hmm. Yes, sir. They are required to do that for evidential purposes.
Well, therefore, wouldn't they be covered in the definition, where the definition touches on any other agency that, sorry, I'm trying to find it. Any other agency that
Yeah, but we wanted expert.
A member of any other agency of the state in which investigative and intelligent gathering powers similar to those exercisable by a police officer under the Police Service Act are lawfully vested? Would you be covered under that?
I don't think that we will be covered over that, because they say on the exercises the powers of a police officer. The prison service doesn't enjoy the powers of a police officer. So that is one of my intention, to have it included.
Thank you.
Now,
Before Senator Lakshmi Dayal, before I invite you, thank you very much, Commissioner of Prisons, for raising two. I realize that you were doing your closing comments and responding at the same time. That is why so we've taken note of your two. Those are two very important areas. One raised in the debate, rehabilitation, and raised in relation to sentencing too. And the second one is one that you've raised that was not raised in the debate. I don't recall it, in the designation of prison officers as law enforcement officers for the purpose of this act, and making sure that it is specified. So I now invite my colleague, Senator Lakshmi Dayal.
Thank you, Chair. Well, firstly, I just want to make a comment, and I want to endorse exactly what Senator Richards has said, that, the public being able to tape things that happen in public spaces, whilst I find it unfortunate that it might be viewed as obstructing police officers in the execution of their duties, and that it should be an arrestable offense. That's a layer of protection that the public enjoys, and police officers also enjoy it too, because I've seen police officers put out their own version of events via recordings on their own cell phones. And with the introduction of body cameras, which we eagerly await from the police service, that would be their level of protection. So we have to balance those scales. So that's just a comment on something that would have arisen. Let me deal with the issue of the prison service being considered a law enforcement agency. You've raised specific examples, Commissioner, of having to take samples and so on, intimate samples and all of that. But this bill is really dealing with someone who you are conducting monitoring, or you're taking something without consent, images without consent, and sharing it, or sharing images that were even taken with consent. Now, a person isn't entitled, once they are in your custody, to object really to images being taken and photographed, if it is, of course, that it's necessary for the purpose of them being in prison. I don't know that you have to take intimate images unless it's, a medical examination and you're required for evidential purposes. But in any event, I think that would be covered. I think that with respect to the voyeurism aspect, if it is that the prison service, does the prison service have a requirement that they need to conduct video surveillance within the prison that may include areas where persons enjoy privacy, like showers and so on, then I can see the issue arising there, that perhaps we may need to carve out an exemption for law enforcement officers or prison officers to be exempt from it if they're doing it in those circumstances. But let me ask you a question coming out of that. Does the prison service have sufficient capacity to ensure that this data is stored in a manner that is secure so that it's not shared? Because the last thing we want is a Facebook live video of inmates taking showers or committing private acts in the shower, as may be the case sometimes. There's a multiplicity of things that perhaps occur within prison walls that may be subject to video surveillance. And, do you have the capacity? So that's my first question. The second one that I want you to, that I think you've kind of answered, but would you support, and I just want to couch it based on what you all have said about rehabilitation and so on, would you all support, and this goes to the TTPS as well, mandatory psychological evaluations before sentencing for any of the offences committed under this law? Not just voyeurism, that's a precursor to other things, but also perhaps the, if someone is engaging in behaviours where they seek to slut shame someone by sharing intimate images after a breakup and all of that, would you support mandatory psychological evaluation as part of the sentencing process to be included in this bill?
Yes, ma'am. Thank you very much, Senator. I think I will, and I think it is in all best interest to have mandatory psychological sentencing. It will give us an idea and it will help with our assessment process in the treatment of the inmates. So if we have information coming to us based on an assessment that was done at a different level, then it will give us an opportunity in attending to the needs and the risk level of the individual. It also will give us the opportunity to place that individual in a location that, it will be safe for him and those around him. So that's, yes, I support that. And your second question, I believe, would have been video storage or storage of
the capacity to keep these things safe without having leaks and so on.
We do have a photography department. We do have an IT department, and we do have our various firewalls in place to protect the data that is stored there. But let me just add one more thing. Sometimes persons come into the prison system with tattoos at various parts of their body. And we are required for identification purposes to photograph these tattoos. It is in this context I'm speaking of. for the protection of the prisons officer.
And sometimes you may have to share that with other law enforcement agencies and so on, like let's
Definitely,
say.
you have to.
Okay.
Definitely.
So I think we perhaps could look at even if it's in a limited way, if we need to create some exemptions for prisons. Yeah. Okay. Thank you so much, Commissioner. That's helpful.
Thank you, Senator.
Thank you. Thank you very much. And our last member, Senator Sagram Singh Suklal, I now invite you to ask your closing question.
Yeah, I just want to apologize for my outburst. I forgot the raise hand feature. So anyway, that being said, as it relates to the Commission of Prisons, I would have listened to some of the concerns, not just made, but the earlier comments. And, I just want to remind respectfully, or put on the record respectfully, that this is indeed a sexual offences bill. And of course, many issues that were raised respectfully, I submit that it falls within the ambit of cybercrime. And that is why, it's unfortunately, this is not a cybercrime legislation. So when we are looking at putting safeguards in this bill as it relates to sharing of certain images and all of that, we have to remember that at all times it is limited to the scope of the bill that appears before us, which is a sexual offense bill and not a bill that relates to all offenses that may be created in a cyber space. So that's just one of the first things that I wanted to say. Now, Chair, is through you, I know, the Commissioner of Police acting would have focused a lot and a lot of questions would have come to this committee relative to evidence and the leakage of evidence, and not just evidence, but images that the police may have. Commissioner, respectfully, I believe in the interest of the public. In my previous incarnation, of course, as a defense counsel, I would have been exposed to understanding the chain of custody of evidence when it comes to the police and the layers of protection that chain of custody provides. And the protection I'm talking about is avoid systems that have been placed, that are in place within the police service as it relates to the custody of evidence that prevents the leakage of that evidence into the public domain, right? Because of course, some of the concerns would have been, okay, we have intimate images that are held by the police, we have videos and that being released. Maybe for the benefit of the public who's listening on, if you could just briefly reiterate the chain of custody of evidence so that at least the public understands that through this chain of custody, there's a layer of protection as it relates to the evidence and it not going out there where persons have access, anybody could just have access to it. That's, of course, if time permits and, of course, if the chairman is minded to allow that question. And that being said, I know a question was also raised relative to audio recordings. What I do know is that we have in America, I know Senator Lakshmi Dayal in her contribution when she would have proposed the audio recordings, she would have mentioned that that's at the debate in the Senate. She would have looked at America. And I myself, after that contribution, I would have looked because it was something that I'm also minded to support. But I know South Carolina, Delaware, and Indiana, for example, their audio recordings that is included in their legislation as it relates to voyeurism and so on. And I know the Commissioner of Police was mentioning his concerns and challenges as it relates to audio recording. But what I can just add to your concerns or just add is that I know that there is comparators that if we do decide to look at audio recordings and include it in the offenses in this bill, there is comparators that do exist that could probably and possibly guide us in making that inclusion. So Chair, I know time is of the essence and that's just my...
Okay, thank you very much. I want to ask you, Commissioner of Police, you've engaged us on a wide range of issues. I would ask you to make your closing comments now, taking into consideration what Senator Sagram Singh Suklal has just raised, in particular, whether in whether you're satisfied with the way in which this sort of material is handled within the police service, whether you believe there is an opportunity to improve, particularly as it relates to the expectation of privacy of the citizens of the country, particularly when data or information may be in the hands of police officers. So I ask you to make your closing comments and to address that particular issue if you can. Thank you.
Thank you again to all and Chair. It's very, very important for us to recognize that the Trinidad and Tobago Police Service jealously protect the whole aspect of the chain of custody, which is the core aspect in us presenting evidence before the court. And if that chain is broken, most of our time, the case is broken. So it is totally necessary that we guard it. Some of these situations that we will have is in the early stages of the gathering of evidence. Our crime scene officers, our cybercrime officers, they operate under particular guides in relation to our standard operational procedures and how things should be documented and move from one step to the other. In fact, in order to enhance that process, recently we established a one-stop shop at our main center at Komoto. And the basic reason for setting up that one-stop shop is that officers will not have to take particular exhibits or even with the process to take it from one place to the next, from one area to another area in order to get all the testings done. It will be done under one roof with a one-stop shop. And that is also to maintain that chain of custody. The cybercrime unit and the RAU have their methodology that they use, and I can't say within recent time at all to hear that particular evidence that came into their custody was leaked. As I said, most of the issues is at the beginning of the particular circumstances or situation. Someone may record some information and send it out in the early zone. Once it comes under the control of our officers, it tends to remain there because it can affect our cases easily. Again, our special victims department, which consists of our child protection unit, consists of our gender unit and the sexual offences unit, has been established for exactly what you all are talking about, where the officers are trained and with a certain level of expertise. And that is the reason why we support the call by the prison commissioner in relation to this psychological testing. And these officers will in fact make note, and they do the interim assessment and screening of these perpetrators. And that documentation is taken and can continue through the case to assist at the end of the day in helping with the whole aspect of sentencing and the sort of treatment the person should be met with. Our cells now are constructed in a particular way, and I think this a special select committee from the parliament was involved in that aspect also, that even our CCTV cameras cannot, in fact, access the areas where our detainees and prisoners are. They may be taking a shower, so you cannot access where the CCTVs are. So that is, we view that in a particular way to deal with that aspect of the recording, which will link to this legislation. We also have the situation that we are required to take photos, intimate photos of persons who are gang leaders or so, if they have tattoos and other things, because it goes to the aspect of putting together our evidence to prove that there is, in fact, some sort of gang affiliation which is identified by these tattoos. And at least the law in this sense is in fact protecting us, and we want to support the prisons in that regard. The other aspects that we pay a lot of attention to is where we look at, we do profiling, not in a negative way. I know some people not use the word profiling, but some of these perpetrators may have, in fact, a pattern in how they operate, and the profiling of them tend to help. And we try our best to utilize the whole aspect of similar fact evidence to help in the prosecution of these persons. So we are looking forward for this legislation to become law, and we know there are some simple amendments that can be made to enhance it. And again, we are in support of it. And especially our Special Victims Unit is looking forward for this because it will assist them tremendously and assist the police service. As I said at the beginning, I'll come back to the police legitimacy and the confidence, because numerous reports are made to us concerning these particular issues, and we are unable to respond effectively because the law in itself is not there to support us. And this legislation will assist us in dealing with it and providing our citizenry a better service. So again, we want to thank Chairman and all who involved in putting together this legislation, and we are looking forward for it to become law. Thank you very much.
Thank you very much, Acting Commissioner of Police. I want to first thank both the Acting Commissioner of Police and the Commissioner of Prisons and your respective teams for attending and participating in such a very important manner, bringing your experience to bear on the discussions. I want to thank my colleagues on this cabinet, on this committee, for their insightful contributions and comments and questions. I want to thank the members of the media following and reporting on today's proceedings, the Law Reform Commission representatives and other representatives from the Office of the Honorable Attorney General, our parliamentary staff, both those in the Secretariat and those in IT in particular, providing the important technical support in these hybrid meetings that we have. And most importantly, I want to thank the viewing and listening audience who have followed and will follow on the rebroadcast and will also continue to make comments on our social media pages. We have taken note of what has been said. And I want to say, Commissioner of Prisons and Acting Commissioner of Police, that you have the opportunity to make further submissions in writing in respect of matters which have been raised today or matters which you believe you should address. I know you've not provided all the expertise and experience that you could have in terms of this broadcast, but you'll have the opportunity to make submissions if you wish to do so. And with all of that said, I want to adjourn this meeting at this time, and thank you very much.
Thank you.
Thank you, Chair.
Yeah.
Thank you, Chair.
Recording stopped.